Al Jazeera Podcasts.
Today, a new Supreme Court ruling leaves birthright citizenship hanging in the balance.
Now, what would happen is something that's completely illegal could and will go into effect for many, many months until it can eventually, if it ever gets to the Supreme Court.
What does the ruling mean for the power of the courts, the power of the presidency, and the rule of law in the United States? I'm Kevin Hirten, and this is The Take.
My name is Leon Fresco. I'm the head of the immigration practice at Holland & Knight. It's a law firm in Washington, D.C. and all across the world, basically. And I am in Washington, D.C. today.
Okay, well, Leon, welcome to The Take. On Friday, the Supreme Court took aim at one of the judiciary's strongest brakes on executive power, which is the nationwide injunction.
The Supreme Court has just released a potential landmark decision impacting the future of birthright citizenship in the U.S. The justices were asked to roll back nationwide injunctions against the president's attempt to redefine the 14th Amendment.
Now, we see this a lot. The lower court will freeze executive orders they see as potentially unconstitutional. So why don't we start with just breaking it down for us? What did the court decide, and why do you think it matters?
What the court decided is that when a private litigant wants to sue and say that either that executive order is illegal or that that regulation is illegal or even that that act of Congress violated the Constitution, in any of those three scenarios, it is no longer the case that one or two or three people can go to a court of law and say, I believe this is illegal. And then that one judge in one location, let's say, Los Angeles or Boston, can then say, yes, I agree with you that that memo or that regulation is illegal. And not only am I going to prevent them from applying it to you, but I'm going to prevent the government from applying this anywhere in the United States. So I'm going to say it's finished. They can't do it unless a court above me decides to overrule me, which would either be the Court of Appeals or the Supreme Court. And what had happened was the Trump administration grew very frustrated that many of its executive orders were being stopped by the lower courts, and there's about 800 of these judges all over the United States. Yeah. And so the key was that only one judge out of the 800 needed to agree that a particular memo or regulation was illegal in order to stop it. And so the Trump administration grew very frustrated about this and decided to ask the Supreme Court to end this practice. Now, having said that, the Trump administration wasn't the only administration that had this happen to it. It's happened during Biden. It happened during the first Trump administration, and it also happened in the Obama administration. So depending on where you stand is depending on where you sit, or where you sit depends on where you stand kind of situation, because sometimes some of the sides have liked this and sometimes other of the sides have not liked it. But now the first time these injunctions are now practically over is during the Trump administration.
Right. So it seems like it takes nationwide power out of the hands of local judges or district judges. It was a 6-3 ruling, and all the liberals were against, and some of the dissents were pretty blistering. Ketanji Brown Jackson said, courts must have the power to order everyone, including the executive, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness. What do you make of this? Has the court just created a zone of lawlessness?
Well, what they've created is a practical problem, which is what is the status quo in a situation where the government truly does something that everyone agrees is 100% unlawful. And it's now going to take weeks or months or potentially years for that case to go to the Supreme Court, because now you can't have what is called this nationwide injunction where one judge can stop it until it gets to either the Court of Appeals or the Supreme Court. At least in that scenario, the status quo was preserved. And then you could, if the Supreme Court or a Court of Appeals decided that the new memo or the new rule was actually legal, then they could actually say, well, no, this is legal, so let it go into play. And that was a more risk-averse manner of doing things. And so it prevented a situation where something that was clearly illegal could actually go into effect. But now what would happen is something that's completely illegal could and will go into effect for many, many months until it can eventually, if it ever gets to the Supreme Court, for them to say, oh, wait a second, this actually is illegal. It should be taken out of it being in full effect.
Well, so it sounds like it's creating a temporary band of lawlessness until this stuff is adjudicated. Now, there's been a number of nationwide injunctions making headlines since Trump took office. I think some of the deportations related to the Alien Enemies Act come to mind.
Trump invoked the Alien Enemies Act to speed up the deportation of migrants with alleged ties to gangs. The 18th century wartime power is supposed to apply to governments attacking and invading the U.S.
Does this ruling render those injunctions immediately invalid?
Yes. Well, what will happen is the Department of Justice will have to go to all of these lower courts that have entered injunctions, and they will have to say to them, please lift your injunctions according to the Supreme Court precedent. And what is going to now have to happen is the lawyers in those cases are going to have to try to do what's called a class action certification, which is they're going to have to show that there are a number of people that are all currently suffering under the same problem as the one or two or three plaintiffs that actually came forward that were actually suing. And that's actually a process that takes several weeks, which is that the court, there's a motion that you file for class certification. You have to show what's called numerosity and commonality, a large number of plaintiffs that all have the exact same facts. You have to show that the law firm who's acting as the class is actually a representative law firm that knows what they're doing, that can get certified as the representative of the class itself. And then, the government gets a chance to object and the court has to then issue a decision. So all of that takes time.
Oh, wow.
And that's time in which these sort of lawless memorandums, if they are lawless, I mean, some of them are fine, but some of them are not fine, can actually take into effect. Now, one of the reasons the court prefers this, even though it's so onerous, is that if a litigation strategy is to get what's called a nationwide class certification, which is that you actually do a class action, that if you win, you do get nationwide relief. The upside for the court is that in that one case, you either win for the whole nation or you lose for the whole nation. Whereas in the current state of affairs prior to the court's decision, you could file many lawsuits in different courts with different plaintiffs strategically, and you only needed to get one judge to agree that you were right. You could have lost in 10 other courts, but you could get one judge to agree that you're right, and that judge could have entered a nationwide injunction. Whereas now, you're going to have to make a very careful litigation strategy. Do I either shrink my class to be for a particular state or a particular judicial circuit, which is sometimes 4 states, sometimes 6 states, etc.? Or do I actually try to do a nationwide class action, which if I win, fine, then I have nationwide relief. But if I lose, now I've banned everyone else in the country from trying to get that relief. And I have to hope that the Supreme Court will take my case. They may not take my case. And then that's it. I've just lost for everyone in this nationwide class action because the Supreme Court is only much more likely to take a case if a memo or regulation has been banned by the court, the lower court, as opposed to if it's been upheld, the Supreme Court is a lot less likely to chime in on such a regulation.
Will this limit the practice of so-called judge shopping, where there's certain judges that these groups, there are all these professional groups that immediately would file these lawsuits and they knew exactly which judge they wanted. Will this make that more difficult?
It will not end it, but it makes it more complicated in that, again, if you choose a nationwide injunction, even if you went to a quote unquote friendly court where you're more likely to get a judge that's friendly to your side than before, you might get the one judge who's not friendly to your side in that situation. And then if you had a nationwide class action in front of that one judge, then you have a very low chance of winning. And so it does make the strategic sort of gamesmanship that happens in these courts more complicated.
Yeah, so there are loopholes left. Too many loopholes for the likes of some of the conservative justices. So at the moment, federal judges can only issue injunctions for people before them in an ongoing lawsuit. Do I have that right? What will that do to the courts?
You have two options. Either if you go just with the named plaintiffs in that case, then the only injunction that can be issued is something that gives those named plaintiffs complete relief. So maybe there's a scenario where the only way to get complete relief is to have the government do something broader than just those plaintiffs, but that's going to be very, very rare and very hard to show. So usually you would just say, as to these plaintiffs, for instance, in the birthright citizenship context, let's say that the government is denying you a passport or a social security number because they're saying you're not a citizen. The court would say, if the court agreed that the birthright citizenship memo that was issued by the Trump administration was illegal, they would say in that situation, well, the relief is that person gets a passport or that person gets a social security number, but not every person gets a passport or every person gets a social security number. The only way to do that is to certify a class of people that are similar in that situation.
We'll have more with Leon after a break. Let's talk about Friday's ruling on the injunction in the Supreme Court, which was looking at birthright citizenship. Remember, Trump's executive order denies citizenship to U.S.-born children of parents who entered the country illegally or they're on temporary visas. So where does this leave the birthright citizenship issue right now?
Well, this leaves the birthright citizenship issue in a very complicated and precarious position because what happens is now moving forward, it was not a retroactive order, so it wouldn't have stripped citizenship from anyone who currently has it. But moving forward, now as the courts are being asked by the Department of Justice to dissolve these nationwide injunctions, and now that the individuals in these courts are going to have to try to certify classes, in the meantime, if a particular individual tries to go in for a passport or tries to go in for a social security number, they may be asked, show evidence that at least one of your parents was a lawful permanent resident or a U.S. citizen. And if you cannot show this evidence, then we're not going to give you the social security number or the passport.
Wow.
And so if there happens to be a class that's been certified in your state or your judicial circuit where you've won, then you may be able to say, well, that what you're doing is illegal. Here's a decision. So you have to give me the passport. Whereas if you were living in some other state, you're not a citizen. So it's a very odd, disjointed situation where literally who is a citizen of the United States depends on what state you live in until the Supreme Court comes back to this case, which if you really wanted to criticize the Supreme Court, which I don't really like doing too much, you could, I mean, a lot of people are criticizing this decision, but I would criticize the fact that on an issue as consequential as birthright citizenship, they didn't bother to take the extra time to decide that issue so that this bizarre patchwork of laws wouldn't even have one day of surviving. We should know immediately if this regulation or this executive order is legal or not, and that they couldn't deign to do that work for just, decide this one more critical issue, to me is reprehensible.
For another year,
Yes.
right? I mean, a lot of legal experts say ruling on this injunction issue was kind of a long time coming. In fact, back in September of 2022, Justice Kagan, who is a dissenting justice, said it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for years, the years it takes to go through the normal process. But I wonder what you make of the fact that it's this issue, this birthright citizenship order, which one Reagan judge said, after 4 decades on the bench, he'd never seen a more blatantly unconstitutional executive order in his life, that this is the issue that the court decides to draw a line in the sand.
Correct. This would be the reason this issue didn't seem to fit well within the context of the nationwide injunction issue is, first of all, if there ever was a case where everyone really was similarly situated, where a nationwide injunction would be needed, it'd be here. Because it was clear that there weren't any fact differentiators. You either had a parent who was a citizen or a lawful permanent resident, or you didn't. And so you could easily say, okay, I know who the group of people affected are. It's every single person who's born in America who doesn't have a parent who's a U.S. citizen or a lawful permanent resident. So I know this. And then the question would be, what would be the justification to keep a status quo in place where only some people could say that they're U.S. citizens depending on where they live, and other people could not say they're U.S. citizens? And would I actually require, if someone in one state needed a passport, that basically what you'd have to do is just go lease an apartment in a different state now and then apply for a passport in that state? Am I comfortable living with that level of absurdity on an issue as important as who is a U.S. citizen? So many people observing that thought, how could the court say that nationwide injunctions would be stripped within the context of this case? But here, the court basically didn't really pay attention to that issue and just dealt with the issue of nationwide injunctions as if it was in a vacuum and without any context as to its application in this very, very, very important issue.
Yeah, I wonder if you can do any tea leaf reading here. It seems like a messy ruling, and I know it was written by Amy Coney Barrett, who's considered one of the key swing judges. Does this tell you that there might have been some dissent in the ranks of the conservatives?
Well, yeah, I think the problem is, I think that there are probably some of the justices who would say that birthright citizenship does not attach from just being born in the United States, that there needs to be something else that attaches to it, which, by the way, I think is not coherent with the actual words, which clearly say if you're born in the United States, unless the government lacks jurisdiction over you, you're a U.S. citizen. And what that means, lacks jurisdiction, is essentially that you're the children of diplomats, because that's who we lack jurisdiction over. And so the real question is, so two questions. One, if you're an undocumented person in the United States, does that mean you have quote unquote immunity such that you can start committing crimes and the government can't prosecute you? And by the way, if that is the case, does that mean today, as we sit here, that if I'm a criminal defense lawyer representing an undocumented person, I should file a motion in court saying you don't have jurisdiction to prosecute my client? So dismiss whatever criminal charge you have against my client because the federal government is saying that you don't have jurisdiction over me. And so those are all complicated issues, but I think the court basically was so intent on getting this nationwide injunction issue resolved that they just said, look, we have to agree on what we can agree upon, and we'll live to fight another day on this birthright citizenship issue.
All right, I have two more questions. One in the weeds type of question on this ruling, and then a big picture question. So on this ruling, there's a lot of what's good for the goose is good for the gander talk right now, meaning that at some point a Democratic president will get the benefit of this as well. And I guess that might be true, but I think it also hinges on the ideological makeup of that future court, right? For example, if a Democratic president issued an executive order banning guns, for instance, which would be in violation of the Second Amendment, you can foresee an injunction ruling by the Supreme Court in a matter of days, right? There'd be a huge amount of pressure. Whereas in this case, an order of banning birthright citizenship, which many believe is just as patently unconstitutional as that would have been, is just allowed to linger until at least next June. So is everyone just at the mercy now of the court's discretion and its schedule? Is that where we're at?
That's absolutely correct, which is that in the end, the Supreme Court is going to decide how critical it thinks a particular issue is and how quickly the briefing can go there. And actually, to his credit, Justice Kavanaugh really said that in his concurring opinion. He said, if there's going to be cases like this, the problem is not the nationwide injunction, so to speak. It's the speed at which the Supreme Court needs to act in order to give nationwide understanding to whether something is or isn't legal. And so he was basically imploring the court, we can't revert to a situation now where we're not acting quickly to try to get to a result in a lot of these cases. Now, we're going to see. The proof is going to be in the pudding. Is that true or not? And again, maybe on an issue like birthright citizenship, we get to it in a year or two, and people are really forced to linger under these crazy situations where in one state you're a citizen and in another state you're not. And then, as you said, if the court really hates a different thing that a different president did, then it doesn't matter. It will just order an expedited briefing and take the case immediately. And so that's the new normal, unless and until one day the court were to decide to not make that the new normal anymore.
Yeah, it's not great. It's not great. Okay, so finally, Trump, of course, is, trumpeting this as a huge victory.
I want to just thank again the Supreme Court for this ruling. It's a giant. It's a giant. And they should be very proud, and our country should be very proud of the Supreme Court today. And we have so many others that worked on this case and other cases.
He's already been criticized for overreaching his power. I mean, I wonder how this ruling affects his agenda. Do you expect him to flood the zone with more unconstitutional orders? Will he be more emboldened?
I think for sure the pressure that the Trump administration was feeling from the courts, especially with regard to many contempt orders that it was worried about getting, and the fact that, you need lawyers to actually be willing to go into these courts to actually make these arguments, that sort of, this has sort of released that pressure and taken steam out of what was becoming a very, very hot kettle, where it was very difficult in some cases to get lawyers to go in and make these arguments. Now the cases are going to take a lot longer. There's going to be a lot less scrutiny by individual judges because they won't be able to make this scrutiny at the same level that they had been making for just individual plaintiffs. The government can even moot out individual plaintiffs' cases, which is something that the government can do to sort of delay the time. So it could say, you know what, you three are claiming that you have birthright citizenship, fine, we'll give you passports. And then you got to start over and get a new lawsuit and try to do it again. And so there's a lot of things the government's going to be able to do that will make it very hard to challenge regulations that the Trump administration is trying to put into place.
Okay. Leon, thanks for clearing that up for us. And thank you for coming on The Take.
My pleasure. Thank you.
And that's The Take. If you're short on time but still want to catch the highlights, check out our YouTube Shorts. We post quick clips of the best moments from our episodes that you won't want to miss. It's a great way to stay connected. Check them out, and we will see you tomorrow.